Hello and welcome to Byju's Exam Prep IAS. A very warm good evening to everyone. I hope all of you are doing good. I welcome you all today to this discussion of Indian Polity Test, the test that you would have given this weekend. In today's class, we'll be discussing the most important questions from that test one by one. We'll be analyzing those questions, and it also gives you a chance to see whether or not your score is on the right track or whether you have certain doubts. Good evening, everyone. Those who have joined in, I hope all of you are doing good. We'll wait for just a couple of minutes and then we'll begin the class in just a bit. Good evening, everyone. Good evening. Just give me a moment. Just give me a moment. We'll just begin in 1 minute. Perfect. Once again, thank you so much for joining in right on time. I hope all of you are doing good. I really hope that all of you did attend this week's test of Indian polity. That was test number 4. And I hope all of you got a good score. Now, the intention of this discussion is very simple. Number one, we will be doing a quick discussion on the important questions that were asked in the test. Secondly, the purpose here is simple. The purpose is the question that you got right, great, absolutely, you deserve all the congratulations. But if there are certain questions that you did not get right, the entire intention in this discussion will be that you should know why is it that certain questions you attempted were not correct. What is it that you were thinking? What was your way of thinking? Were you not thinking in the right direction? We'll be discussing all of that to make sure that if that test or that kind of a question appears again, you are in a much better position to answer. So now, without debating any further, let's quickly start our discussion with the important relevant questions that we have. So we start our discussion with question number 1, pretty easy question to answer. This is a question regarding the writ jurisdiction of Supreme Court and the High Courts. First statement: the writ jurisdiction of Supreme Court is wider than that of the High Court for issuing writs for other than fundamental. Right or wrong? Absolutely wrong. I'm sure all of you would know this. The difference is Supreme Court can only issue writs for fundamental rights purposes. They can only issue writs for fundamental rights. However, on the other hand, the High Court can issue writs for fundamental rights plus other legal rights as well. So for other legal rights as well, the High Court has the power to issue the writ. Writ, in very simple terms, is an order issued by the court to ensure that whatever rights have been violated, they are restored. The first statement thus is wrong. Second statement: the writ jurisdiction of Supreme Court and High Courts are part of the basic structure of the Constitution. Yes, this is correct. Both of these are part of basic structure of the Constitution. The Supreme Court said this in a very famous case called L. Chandra case of 1997. I hope all of you have heard the name of this case. L. Chandra case of 1997 is the case where the Supreme Court had said that our powers of writ jurisdiction are a part of the basic structure of the Constitution and thus they cannot be curtailed. This was a pretty simple question to answer. Question number 2. With reference to Lok Adalats in India, consider the following statements. Number 1. It is restricted to handling cases that are pending in the court and not those that are at a pre-litigation stage. What is pre-litigation? Pre-litigation means those cases that have not gone to the court so far. Pre-litigation means those cases that have not been filed so far. So the first statement is saying that if a case has not been filed in the court so far, the Lok Adalat cannot hear that case. This is actually wrong. They can hear pre-litigation cases also and the cases pending in the court as well. Both of these cases they can hear. Second, it cannot handle criminal case. Now this is where it is pretty interesting. Lok Adalat can even handle criminal cases. This is also wrong. So basically there are two types of offenses. there are compoundable offenses, and then there are non-compoundable offenses. Compoundable offenses are ones which are criminal in nature, but they still can be heard in Lok Adalat. Basically, in simple terms, what are compoundable offenses? Compoundable offenses are something that can be settled outside the court also. For example, let's say there is a case where someone actually had an accident with your car. Okay. Now, they damage your car. Now, you want certain money out of them. They are not giving you money. You go to the court. So, when they go to the court, they tell you, let's settle the case outside the court. I will give you some money, withdraw the case. That is allowed. That are called compoundable cases. Compoundable cases can be settled outside the court. They can be heard in Lok Adalat. Non-compoundable means, in simple terms, serious cases, serious offenses. So, for example, let's say there's a murder case. Let's say a person is charged that you committed a murder. So, the person who got killed, their family members cannot say, okay, we will settle this outside the court. They cannot say, give us some money, we will withdraw the case. That is not allowed, because those cases have to be heard by the court. Those are non-compoundable cases. Lok adalats cannot hear non-compoundable cases, but they can hear compoundable cases, even though they are criminal in nature. Second is also wrong. Third statement, decision of the Lok Adalat is final and binding on all the parties. No appeal lies in any court. Absolutely correct. So out of these three, only one statement is correct. That is the third one. So the answer here has to be A. Again, I will repeat, the purpose of this discussion is not to check how many of your answers were right or wrong. That you can check from the answer sheet also. The purpose of this discussion is, even if you got a question right or wrong, I want you to check your way of thinking. Were you thinking in the correct manner? Were you thinking on the same lines as we are discussing or not? If that is the case, then you would be in a position to answer such questions. As you know, as I told you earlier, the Lok Adalat, once they give the decision, it cannot be challenged. That is absolutely true. The reason being that people come to Lok Adalat to negotiate mainly. So Lok Adalats usually give their decision not to say one is right, one is wrong. The entire purpose of Lok Adalat is mainly to negotiate between the two parties. They only give the decision once both the parties are happy with it. That is why once they give the decision, there cannot be any appeal against that. So third statement is correct. First and second are wrong. Only one statement is correct. So the answer here becomes A. Next question. Which of the following are audited by the CAG, Comptroller and Auditor General? LIC, expenditure from the Public Account of India, audit of local bodies on request of the governor of the state, district or regional funds under the 6th schedule of the Constitution, all bodies or authorities substantially financed from the center and the state revenues. It's a very interesting question. By default, most people assume that if there is a government company, then CAG will audit it. But that is not always true. There are certain government organizations that are not audited by the CAG. For example, LIC is not audited by the CAG. LIC, in fact, is audited by private expert auditors. So they are private auditors, they are not CAG. The CAG helps in choosing those auditors, but the CAG does not audit the LIC. If you know this fact, you would be able to eliminate B and D. The remaining options are A and C. The correct answer here is actually C. Except the LIC, all the other organizations that are mentioned here are audited by the CAG, the Comptroller and the Auditor General of India. I have a question here. Dipali saying, how to know the optimal number of questions to be attempted? See, it depends on paper to paper. When you have prepared for 1 year, or in some cases even for more than 1 year, what happens is you get a very good idea when you look at the paper. Is it a tough paper? Is it an easy paper? When you get an idea it's an easy paper, then you have to attempt at least 80, more than 80, 85, 90. That's a ballpark figure. On the other hand, if you get a sense it's a very difficult paper, most of the things that you see in the paper are not something that you have usually studied, then obviously you can reduce your number of attempts, mark, maybe aim for 70, 75 attempts. So it depends on paper to paper. There is no one single answer to how many questions should you attempt. Then I have one more question. There was a judgment, L. Chandrakumar case, where Supreme Court gave the verdict parties can appeal against tribunal judgment. Yes, that is no. So Lok Adalats are not tribunals. Lok Adalats are entirely different. Tribunals are entirely different. They are not the same. Against tribunals, you can appeal, but not against the Lok Adalats. Perfect. Next is question number 4 that we want to discuss. Consider the following statements with reference to Lokpal. Now, I'm sure all of you would have read about the Lokpal. It's a statutory body that has been recently established. First statement, expenses of the Lokpal are charged upon the Consolidated Fund of India. Absolutely correct. Second, on ceasing to hold office means when the term is complete, chairperson of Lokpal is restricted from contesting election to Panchayat for a period of 5 years. It's a pretty interesting statement. This is actually true. In simple terms, basically, the law is once the Lokpal chairperson has ended the tenure, after that, for a period of 5 years, the Lokpal chairperson cannot contest any election in India, including the parliament elections, the state elections, or even election for panchayat and municipality. They cannot contest. So yes, they cannot contest even the panchayat election. So second statement also is true. Third statement, the Lokpal has jurisdiction to inquire into allegations of corruption against the Prime Minister. True or false? What do you think? The Lokpal has a jurisdiction to inquire into the allegation of corruption against the Prime Minister. What do you think? True or false? Yes. Yes, it is true. It is true. Then 50% of the members of Lokpal should be from scheduled caste, scheduled tribes, other backward classes, and minority only. What about the fourth statement? Is it true or false? What do you think? The fourth statement, is it true or false? The fourth statement is actually false. Why? This is false. Why? The word only makes it wrong, because in this category you can also include women. 50% of the members of the Lokpal have to be scheduled caste, scheduled tribe, OBC, minority, or women. Now, I hope all of you have already read about the Lokpal. The Lokpal consists of the chairperson and maximum of 8 members. Out of these 8 members, 4 are judicial members. They come from a judicial background. And other 4 are non-judicial members. But overall, out of these 8, at least 4 have to be from scheduled caste, scheduled tribe, OBC, minority, or women. So 1, 2, 3 statements are correct. The fourth statement is wrong. So the answer becomes C. The reason being that fourth statement is incorrect. The other 3 are absolutely correct. Ankur is saying sometimes the word only does not help. Yeah, I'm not saying the word only will always tell you this is an incorrect statement. It gives you a hint, but please don't make it a habit that as soon as you see the word only, you think this is the wrong statement. That will not always happen. Let's see the next important question. We jump on to question number 7 now. With reference to powers of the High Court, consider the following statements. Number 1, death sentence issued by Sessions Court can be confirmed by the High Court, or has to be confirmed by the High Court before its execution. Absolutely correct. Sessions Court basically is a district court only. So when the district court is hearing criminal matters, that is called a Sessions Court. The Sessions Court has the power to give death sentences also, but before it is carried out, before it is executed, the High Court has to first confirm it. Second, the High Court can exercise both administrative and judicial superintendence over subordinate courts. This is also absolutely correct. What does it mean? See, there is a difference between Supreme Court's working and the High Court's working. The Supreme Court is not really responsible for looking into the working of lower courts. So Supreme Court doesn't look into how the lower courts are working. Yes, they can give certain order to lower courts, that is their power. But the High Court is actually given the powers to exercise jurisdiction over all the courts in their territory. So for example, if there is a High Court in Karnataka, the Karnataka High Court has to look into the working of all the lower courts in the state of Karnataka. They will help with the appointment of the district judges also. They will also see if the judges have to be transferred. They also see the quality of judgments being given a right or wrong. So High Court does have a jurisdiction, superintendence over all the subordinate courts. Subordinate courts basically refers to all the courts below the High Court. So district court, sub-divisional court, all the courts below the high court are under the category of subordinate courts only. Next, the judgment of a high court cannot be challenged by any lower court. Absolutely correct. The judgment of the high court cannot be challenged by lower court, obviously. It can be challenged in a higher bench of the high court, or it can be challenged in the Supreme Court, but not in the lower court. All the three given statements are correct. So the answer here becomes C. I don't think it's a pretty difficult question to answer. For question number 7, mark the answer as C. Next, we move on to question number 10. In which of the following cases a constitutional bench can be set up in the Supreme Court? Now, what exactly is a constitutional bench? The definition of constitutional bench is a bench having at least 5 Supreme Court judges. So a bench formed in the Supreme Court having at least 5 Supreme Court judges will be called a constitutional bench. Now, constitutional bench, as the name suggests, usually is established when they have to look into matters which are related to the interpretation of the Constitution. Let's look at this. First statement. If a case involves substantial question of law related to interpretation of Constitution, yes, constitutional benches handle these cases. Second, if a 2-judge bench and a 3-judge bench of Supreme Court delivers conflicting judgments on the same issue, yes, then also a higher bench will take up the matter, that is a constitutional bench. Third, when President seeks Supreme Court's opinion on the law, on any law or fact, absolutely correct. Which article is this, by the way? Which article is this, by the way? Which article says that the president can ask for advice? Yes, Article 143. Absolutely correct. Article 143. Then, an appeal from a lower court in which a sentence of death or imprisonment or life has been passed. No. See, when these kind of cases come in, when cases about death, imprisonment for life, these cases are not constitutional matters, because in such cases you don't have to interpret the Constitution. You don't have to apply your mind on what the Constitution makers wrote. These kind of cases go to division bench, they don't go to constitutional bench as such. So the answer here has to be 1, 2, and 3. First, second, and third, these are instances of when a constitutional bench is established in the Supreme Court, not the last one. Next is question number 11. Consider the following statements with reference to National Commission for Scheduled Castes. As you know, it is a constitutional body that looks into the welfare of scheduled castes. Now, first statement. The state governments are required to consult the commission on all major policy matters affecting the scheduled castes. Right or wrong? Yes, absolutely correct. Second, the Minister of Social Justice and Empowerment is the chairperson of the commission. No. I'm sure in Indian polity you have read about this body. It's a constitutional body, National Commission for Scheduled Castes, just like there is a National Commission for Scheduled Tribes and Backward Classes also. All of these have their own separate chairpersons who are appointed by the President of India on the advice of the government. The minister by default is not a chairman of this commission. That is wrong. Third, the commission, while exercising the power as civil court, can direct the government to grant transfer to any individual for a particular place. No, again wrong. Why? Understand this, all these commissions, be it the Scheduled Caste Commission, the Scheduled Tribe Commission, Backward Classes, Human Rights Commission, for all these commissions, understand one thing in common. They cannot direct. Direct means giving an order. So basically, they cannot give an order. What they can do is they can only recommend. The only thing that they can do is recommend the government. They cannot direct. Direct means giving an order that yes, the government has to transfer them from here to here. That does not really happen. These commissions can only recommend, and the government then takes a final call whether the transfer has to be done or not. In usual cases, they don't even give such suggestions. They may recommend certain action, but they don't really order or direct anything to the government. So second and third, both statements are wrong. Only the first statement is correct. So for question 11, the answer has to be A. I hope all of you got this absolutely right. Ashwini is saying, can chairperson of Lok Adalat contest election after 5 years? I'm not sure, Ashwini, if you're confused between Lok Adat and Lokpal. We were talking about Lokpal back then. For Lokpal, yes, the chairman can contest after 5 years. For Lok Adalat, there's no chairman as such. So that's a different thing altogether. Next, question number 13. Slightly difficult question, but this kind of question has been asked earlier in the UPSC. The question is, who amongst the following are entitled to free legal service under Legal Services Authority Act of 1987? I am sure all of you would have read about NALSA. I'm sure all of you would have read about NALSA. NALSA is basically it is National Authority for Legal Services. Now, this NALSA has the responsibility of ensuring that they provide legal aid to people at the central government level. Similarly, we have state authorities, we have district authorities, etc. Under the Legal Services Authorities Act, such organizations make sure that they provide free legal aid, means they provide free of cost lawyers to those who can't afford them. These free of cost lawyers are given to only certain category of people and not to all of them. And this is what you have to answer. Number one, women employed in high paying jobs, would they get the lawyer or not? Yes. Basically, women, irrespective of how much they are earning. So women, irrespective of their income, whatever their income is, doesn't matter. Irrespective of their income, they will get free legal aid if they want. Members of scheduled tribe, yes. Victims of ethnic violence, yes. Victims of beggary under Article 23, industrial workmen, disabled people. In short, all of these are eligible to get free help under the National Legal Services Authority. Now, answer one more question for me. Let us assume, and please don't Google it, you have to answer this carefully. Let's assume that I am not in any of these categories. And this is true, I'm not in any of these categories. At what income level or below what income level will I be eligible to get free legal aid? Below what income level can I also get legal aid if I'm not in any of these categories? Okay, I am getting, most of you are giving the correct answer. Most of you are giving the correct answer. 1 lakh. 1 lakh per annum. 1 lakh per annum. So basically below 1 lakh per annum, you also qualify. One other exception is if you are going in the Supreme Court, then at the Supreme Court level, it is 1.25 lakh per annum. So if you're earning below 1.25 lakh per annum, then you will be eligible for getting free legal aid in the Supreme Court cases. In other courts, up to 1 lakh per annum, you might get free legal aid. All these are eligible to get free legal aid. First option, as I said, women employed in high paying jobs, low paying job, doesn't matter. All women are eligible to get this free legal aid. So irrespective of their income, women can also get this. That is why the answer here has to be D. Next, question number 15. By the way, the last question that we had, a very similar question has been asked by UPSC in the past. It was a difficult question to answer. Which of the following best describes advocate on record in the Supreme Court of India? Advocate on record. Now, it's a very interesting thing. What is an advocate on record? See, let me ask you this question. Okay. Let's say I am a lawyer, I have a law degree, I have a license, and I am registered by some bar council. Let's say I'm registered by bar council in the state of Bihar or UP or Delhi, whatever. Tell me this, if I am a lawyer living somewhere in, let's say, Puducherry, can I go and fight a case in Supreme Court? Or the Supreme Court only allows certain lawyers to come and argue a case? What do you think? If I'm living in Chandigarh, in Puducherry, in Mumbai, in let's say Tripura, can I go to the Supreme Court and fight a case? What do you think? Most people are saying yes. I'm not saying should I be allowed or not. I'm saying am I allowed or not? Some people are saying no. Now increasingly people are saying no. Okay. Now please understand this. If I am a registered lawyer, if I am registered with the bar council anywhere in the country, I can fight a case in the Supreme Court. However, there is one very interesting thing here. There is a category of lawyers who are called advocates on record. Now, what do you mean by that? Basically, advocates on record are those lawyers, only they are allowed to register a case in the Supreme Court. Please understand this. If you have a case in the Supreme Court, if the lawyer has to register a case in the Supreme Court, only advocates on record can register the case. The case can be argued by any lawyer, that is fine. But advocates on record are the only lawyers that are allowed to register the case in the Supreme Court. Now, who are these? How do you define them? They're actually those who are registered by the Supreme Court, and they have to pass an exam conducted by the Supreme Court specially. They have to pass an exam specially conducted by the Supreme Court. They have to be registered by the Supreme Court. Only they are called advocates on record. Not all of them are advocates on record. Only those lawyers who are advocates on record can file a case in the Supreme Court. It can be contested by others as well who are associated with them. Senior advocates, etc., there is no proper definition. Supreme Court or High Court, if they respect a certain lawyer, they can give this designation to any lawyer that you are a senior advocate. There is no exam that you have to pass to become a senior advocate. Advocates on record specially has to go through an exam conducted by the Supreme Court. So basically, there is a proper eligibility criteria also to become an advocate on record in the Supreme Court. For example, the Supreme Court sets the criteria. They have said you should have at least 4 years of legal practice. You should have at least 4 years of legal practice. You should be registered at some bar council. You should be registered at a bar council somewhere. Also, you should have 1 year of training under an advocate on record. You should have 1 year of training under some other advocate on record, and again, obviously, pass the Supreme Court exam. So Supreme Court conducts this examination, you pass the exam, you qualify all these, you are in this category, so you will be called advocate on record. Someone is asking how many are there advocates on record? There are a lot of them. There's a long list. You don't have to remember that. So that is how the advocates on record are formed. Remember, any other lawyer can also go and fight a case in the Supreme Court. It's not that the advocates on record only can fight a case, but they are the only ones allowed to register cases in the court. Next, question number 17. Which of the following initiatives are components of Disha scheme recently seen in the news? So Disha was a scheme. It was in the news. I hope all of you read this. Which of these are components? Number 1, Tele-law, Nyay Bandhu, legal literacy, legal awareness, national service, and tracking of electronic processes. Not an easy question to answer. The correct answer actually is A. Tele-law, Nyay Bandhu, all these are initiatives to make it easier for people to get justice. For example, Nyay Bandhu basically means that you will be able to consult lawyers, even if you don't know any lawyer. You will be able to consult certain lawyers online, on phone, on video call, etc. All these are initiatives to make the judicial system better in India. But out of these, only first 3 come under the Disha scheme. The last one mainly is national service tracking and electronic processes. Basically, this last one is as soon as there is a case in the Supreme Court that ends, all the parties who are related to the case will automatically get all the papers, all the documents related to the case online. They don't have to come to the court time and time again. They don't have to come and apply that I have not got a copy of the judgment, I have to appeal. So all the documents related to the case will automatically be instantly be online transferred to the people who are concerned with the case. That is what the National Service and Tracking of Electronic Processes is. This is not a part of the Disha scheme. So the correct answer here has to be A. I will repeat one thing very quickly that I said earlier as well. Those who have joined in slightly late, when we discuss these kinds of questions, please understand, if you marked an answer wrong, there is not a worry that you have to actually be sad. Please don't worry about the fact that you marked an answer wrong. What I want you to gain from such discussions is, see if you are thinking in the right manner or not while solving the answer. If you are not thinking in the right direction, if you just got the answer right by luck, then you are in trouble, because next time you might get that wrong as well. So rather than judging yourself on the basis of marks, I would highly advise you to judge yourself on the basis of how were you thinking while solving this question. Secondly, every new question, every tough question is actually an opportunity for you to learn new things. Pray to God that before the prelims examinations, you should see as many tough and new questions as possible, so that on the day of the prelims, you don't have to face any tough questions. So when you see these kind of questions, don't worry if you got it wrong. Think of what were you doing wrong. Next, question 21. Which of the following cases are investigated by the CBI, that is the Criminal Bureau of Investigation? Bank fraud and cybercrime, circulation of fake Indian currency notes, organized crime under the IPC, investigation of cases under the Prevention of Corruption Act. The correct answer here actually is D. All these cases can be investigated by the Central Bureau of Investigation, that is the CBI. So CBI has different divisions actually. So CBI has an anti-corruption division. CBI also has an economic division. And they also have division related to other crimes. So basically they have the capacity to look into almost all kinds of cases. They look into all these cases. Whichever case is given to them by the central government or by the judiciary, they will look into such cases. The correct answer here has to be D, not something that you should have gotten wrong here. Next, question number 19. Consider the following matters. You have to tell how many matters fall within the original jurisdiction of the Supreme Court under Article 131. So basically, in which of these matters originally can you go to the Supreme Court to raise this issue? Let's see. Border dispute between the states, river water dispute between the states, matters under the consideration of the Finance Commission, or election petitions filed against the election of the Lok Sabha. Let's look at these one by one. The Lok Sabha election petitions actually go to High Court. The easiest way to remember is, if you remember the Indira Gandhi case, remember the Indira Gandhi case where before she imposed emergency, there was a case filed against her election, the Allahabad High Court, where the Allahabad High Court had said that no, your election is illegal, you have to resign, they suspended her. So that is a good way to remember that when you have any election complaint with respect to Lok Sabha elections, that goes to High Court and not to the Supreme Court. In the Supreme Court, which kind of election cases will go? If there's a president election matter or vice president election matter, if there is an election dispute about president or vice president election, that will go to Supreme Court directly, and not the Lok Sabha election, that will go to High Court. Second and third also are wrong. As you know, the water disputes are resolved by interstate water tribunals. Supreme Court doesn't look into it. Even the matters of Finance Commission don't go into Supreme Court. Only matter in all of this that will come under original jurisdiction of the Supreme Court is one. If there's a border dispute between the states. So out of all the four, the only first statement is correct, and that is why the answer has to be A. All the other ones here are wrong. Next, consider the following pairs. You have to tell which of these is correctly matched, or how many of these are correctly matched. First, mercy petition. It is a petition filed by a convict to have capital punishment converted to lesser form of punishment. Absolutely correct. Second, review petition. Is it a petition filed as a last resort to ensure that to avoid a miscarriage of justice, abuse of power? No. This is actually curative petition. Review petition is this one, to consider or to ask the Supreme Court to reconsider the judgment. Second and third are matched against each other. First one is absolutely correctly matched. First, you file the review petition asking or requesting Supreme Court to review their judgment. In the end, you file the curative petition. That is the last petition that you can file in the Supreme Court. Only one pair is correct. That is the first one. So the answer here is A. Himanshu, I would request you to only type your comment once. Please don't spam it. Please don't copy paste it time and time again. We can read it just once. Because when you copy paste it, all the other comments get hidden. So please have some patience. Your questions will be answered, but please don't paste it time and time again. Okay. Anyway, we'll come to that. Don't worry about that. So for 25, the answer has to be A. Next, question number 24. Consider the following statements with reference to State Public Service Commission. Number one, Constitution has provided for discretion to the President of India to decide the strength of the commission. Second, the governor has the authority to extend the additional functions of the commission. And third, governor can suspend the member of a commission to whom a reference has been made to the Supreme Court for the removal. You have to tell which of these given statements is or are correct. Now, this is a very interesting question because all of you read about the public service commissions, but somehow these are a lot more in detail. First statement, for example, Constitution provides for discretion to President to decide the strength of the commission. No, President can decide the strength of UPSC. The question is about State Public Service Commission. So for State Public Service Commission for respective state, the governor decides that and not the president. The president will do that for the UPSC. So first statement will be wrong. Second, governor can extend additional functions to commission. No, the state legislative assembly can do that. So for UPSC, for example, to extend their functions, Parliament can extend their functions. For the State Public Service Commission, the State Legislative Assembly can give them more functions apart from conducting this examination, etc. So that is also not correct. Third is actually correct. Many people would have a confusion here because we usually read that the President can remove the members of State Public Service Commission, which is true. The President can remove the members of State Public Service Commission, but when it comes to suspension, the governor can suspend. There's a difference between the two. Please understand. The governor can suspend, yes, the president will remove. So third statement actually is true here. You have to tell how many of these are correct. Only one of these is correct. Only one of these is correct. That is why the answer here is A. The other two statements here are wrong. After I discuss this question, 25, we will be about 25% past our discussion. So I will take a few more questions that are now in the chat. So don't worry, I'll take up some questions. Question 25, with reference to permanent Lok Adalats, consider the following statements. Number one, permanent Lok Adalats have jurisdiction over pre-litigation matters up to rupees 1 crore only. Second, they provide for adjudication of cases regarding public utility services. Third, unlike Lok Adalats, permanent Lok Adalats is a reconciliation as well as adjudicating body. All these given statements are absolutely correct. See, Lok Adalats earlier were not permanent bodies, meaning that earlier Lok Adalats were organized once in few months. People could take their case, resolve their case and go home. But the government realized its importance and the government a few years back set up permanent Lok Adalats, just like court. You can go there any day. But the difference is the permanent Lok Adalats will only hear public utility related cases. So if there's a water bill, electricity bill, those kind of bills, there's an issue with that, you can take those cases and they will be hearing those cases only up to value of rupees 1 crore and not more than that. That is why the answer here is C. All these C given statements here are correct. Let me take up a few questions very quickly here. Okay. Himanshu had a question. Let me take that up. River water dispute in case of water use, whatever is living condition or people depend on water under Article 21 comes under Supreme Court. Yes. See, your argument is absolutely correct. People have gone to Supreme Court, and there's another comment here. I'll take that up. Ranjan is saying Kaveri water dispute has gone to Supreme Court. Understand something. When there is an interstate water dispute, again, the law is interstate water disputes are not adjudicated by the Supreme Court. As simple as that. However, since there is a loophole in the law, I'll tell you two loopholes. Under these two loopholes, people go to Supreme Court, but they don't go to the court to decide how much water will be given to which state. One loophole under which people go to Supreme Court, which happened in the Kaveri water distribution also, is that the states are not implementing the order of the tribunal. So people have gone to Supreme Court saying that tribunal order is not being implemented. For example, when Kaveri water dispute was resolved by tribunal, Tamil Nadu went to Supreme Court multiple times saying that Karnataka is not implementing the tribunal order. So you can go to Supreme Court in that case. Other big loophole is many people have gone to Supreme Court saying that because we are getting lesser water, it is a violation of our fundamental rights. So please do something. So in such cases, you will not call it a case of interstate water dispute. That is a case of fundamental right violation where you can go to Supreme Court. So the question is, can interstate water disputes be resolved by the Supreme Court? The answer is still no. So please don't worry. Everything that you have learned is correct. You just have to understand it. You cannot go to the Supreme Court to resolve interstate water disputes. There are loopholes which have been found by people. Number one, people go to the Supreme Court saying that their fundamental right is being violated, and secondly, they go saying that the states are not implementing the order. So I hope that this answers your query. Then I have a question from Mahesh. What is the difference between permanent lok adalat and normal lok adalat? So normal lok adalat is not a court where you will go every single day. Normal lok adalat, basically what happens is after 2 or 3 months, you will see a big ad in the newspaper that lok adalat is being organized at this place on this day. You can go and resolve your cases. These are normal lok adalats. Normal lok adalats are not permanent. They are organized once in 2 months, 3 months, and people can go and take their cases. Permanent lok adalats have now been set up just like a court where you can go every single day. But permanent lok adalats can only settle issues related to public utility cases. Public utility services means water bill, electricity bill, transportation, etc., insurance. Those are the things that can still be settled in the permanent lok adalats. That is the only difference. Shweta is saying cases filed in Supreme Court can be fought by any advocate or bar counsel or 4 years practice, etc. No, the conditions that I told you are to become an advocate on record. The conditions that I wrote here are the conditions that you have to fulfill if you have to become an advocate on record in the Supreme Court, not to fight a case in the Supreme Court. To fight a case in the Supreme Court, you just have to have a law degree and you just have to be registered with a bar council. Kritika is saying if lower court challenges it in Supreme Court, then high courts are technically challenged by lower court. You are thinking too much. Lower court cannot challenge something in the Supreme Court. Individuals go to Supreme Court. Courts don't go to different courts to challenge cases. So let's not go into too much detailing of that because you're just confusing yourself. Have you heard lower court going to Supreme Court against the high court? That's like the youngest sibling going to the parents against the middle sibling. Let's not confuse it. That is not what happens. Individuals go to court, states go to court, authorities go to court, courts don't go to court. So let's not get there. Okay, let's move on then. Let's see what are the other questions that we have. Question number 26. With reference to the appointment of the Chief Justice of the Supreme Court of India, recently seen in the news, consider the following statements. Number one, selection of Chief Justice is usually based on the seniority amongst the judges of the Supreme Court. Yes, true, because that is what usually the case is. When the Chief Justice of India retires, usually the next senior most judge becomes the Chief Justice of India. Second, outgoing Chief Justice tenders his or her recommendation to Union Minister of Law and Justice for the appointment of the next Chief Justice. Again, yes, absolutely true. Third, the Chief Justice takes an oath to preserve, protect, and defend the Constitution and the laws. This is wrong. The oath to defend the Constitution is actually taken by the President of India. This oath that we are seeing here, oath to preserve, protect, defend the Constitution, this oath is taken by the President and not the Supreme Court Chief Justice. The correct answer thus is easy. 1 and 2 are correct. The answer has to be A. I hope most of you got this one right. Next, with reference to Gram Nyayalayas, recently seen in the news, consider the following statements. Number one, Gram Nyayalayas are mobile courts. They exercise the powers of both criminal and civil courts. Mobile courts means they basically are not at one single place. They can be organized at one place today. They may be organized at some other place tomorrow. So they are mobile courts. They keep on going from villages to villages. That is absolutely true. Second statement. The state governments are responsible for establishing Gram Nyayalayas in consultation with the respective high courts of that particular state. Again, the statement is absolutely correct. The state governments establish it, they consult the high court, where do we have to establish, how many judges, etc. Third, non-judicial members can also be appointed as the presiding officer of Gram Nyayalayas. No, non-judicial members cannot be presiding over the Gram Nyayalaya. So basically what happens is Gram Nyayalayas are presided over by judicial members. Judicial members means those who have retired, let's assume, as a district judge, those who are still working as a district judge. So it is the judges only that can preside over the Gram Nyayalayas. The difference is in the Gram Nyayalayas, you can have certain non-judicial people also, like local councillors, volunteers. They can come and help the people who are involved in the case. But when it comes to running the Gram Nyayalaya, who is the head of Gram Nyayalaya, that has to be a judicial member only and not a non-judicial member. So third statement is wrong. Fourth statement, Gram Nyayalayas are guided by the principles of natural justice. Absolutely true. Now, what exactly is this concept of principles of natural justice? Understand something. See, you all would have heard that when you go to the court in India, the problem is that the courts in India take a lot of time. The reason why the courts in India take a lot of time is that the courts in India, when they are hearing any matter, they have to be following all the rules. For example, there is a code of civil procedure. Code of civil procedure means it tells the court how to hear a civil case. Similarly, we have a code of criminal procedure. I'll give you a very simple example. Let's assume me and you, we have a case in the court. Okay. Now the court has given us a date that both of you should come on 10th of March. 10th of March, I reach the court, but you don't come to the court. You tell the court, sir, I'm sick, I have fever, I can't come. The court has no option but to give some other date. And the date that they will give is then after 2 months, after 3 months, because this is what the procedure is. Even if the judges think that you are not coming because you are just looking to extend the case, even then the courts would have to give you a lot of chances. They would have to give you enough chances to come back again. This is a problem with the code of civil procedure, code of criminal procedure. Now, what happens is that is why most of the cases in the courts actually go for such a long time, because these are loopholes that lawyers actually exploit. So what happens is when government sets up other kind of bodies to deliver speedy justice, for example, for speedy justice, we set up Lok Adalats, we set up the Gram Nyayalayas, or even the tribunals. When we set up these kind of things for speedy justice mainly, understand any body that is established by the government to provide speedy justice can never follow the same procedure. Because if they follow the same procedure, then they will also work like a court. They will also give decisions after 20 years, 30 years. So these bodies don't follow the code. What do they follow? They follow principles of natural justice. They follow principles of natural justice. What are these principles? For example, principle of natural justice says that a person who is accused in the case cannot be the judge in the case. Simple. If there is a case that is going against you, you cannot go and hear the case. As simple as that. Secondly, everyone has the right to be heard. So if there's a case going on against anyone, the person has a right to be heard, has a right to explain. And third, innocent until proven guilty. All these kind of things have to be followed in the principle of natural justice. But you don't have to follow so much procedures that the courts have to follow. So all these institutions, any institution that is established by the government to give speedy justice will always follow principles of natural justice. They will not follow these procedures, because if they do, then they will just be like the courts, and they will also have a lot of delay in presiding over the cases. Next, question number 30. With reference to National Judicial Data Grid in India, recently seen in the news, consider the following statements. Number one, it is a platform under the aegis of E-Committee of the Supreme Court of India. Second, the case related to the orders, judgment, or it contains data related to orders, judgments, case information of High Court and Supreme Court only. Third, it provides consolidated figures of pendency of cases in the judiciary. Now, this is something that has become pretty famous now. This is a platform, it's an online portal done by the Supreme Court of India, where you can actually see real time how many cases are pending in India, what are the kind of cases, at what levels are the cases pending, so on and so forth. First statement is true. Third is also true. Second is wrong. Why? Because right now, they actually give you data about district courts and high courts. The data that you get right now is about district court and high court. For Supreme Court, it is still in the form of where they're testing actually. For Supreme Court, they're still testing. So case by case data of Supreme Court has still not been given. The case by case data of high courts and district courts can be found, but not of the Supreme Court. That is why second statement is wrong. First and third here are correct. So the answer here becomes C. I hope all of you got this one right. Make sure after the class, you just Google National Judicial Data Grid. Go to the portal, see how it works. It will be pretty easy for you to understand then. Question 32. Consider, or with reference to the removal of a judge of the Supreme Court of India, consider the following statements. Number one, the motion to remove a judge in the Supreme Court can be introduced in either house of the parliament. Yes, it can be introduced in either house of the parliament. Motion to remove a judge of the Supreme Court, if admitted, will lapse on the dissolution of the Lok Sabha. No, that will not happen. Even if the Lok Sabha gets dissolved, the motion to remove the Supreme Court judge will go on when the next Lok Sabha is formed. It will not be dissolved in between. That is written in the law. So it's written in the law, the Supreme Court judge removal resolution will not lapse, even if the Lok Sabha is dissolved. The correct answer here would be A, because only the first statement here is correct out of the two. Next, which of the following is or are exclusive powers available to the Supreme Court of India? First, it can allow special leave petition on any matter before any court or tribunal. Second, the Supreme Court can withdraw cases pending before High Courts and decide on them on its own. Third, only Supreme Court can declare a law by the central government as unconstitutional. Which of these given statements is or are correct? Pretty interesting question. Let's look at the third statement first. Can only the Supreme Court say that the central government law is illegal, unconstitutional? No. Even the high courts can say this. See, the Indian judicial system, we do not have separation of laws. We don't have a system where High Court will decide state cases and Supreme Court will decide central government cases. That is not the case. So even if a law is passed by the parliament, both Supreme Court and High Court have the power of judicial review over such laws. So third statement is wrong. Even the high courts can do that. First, Supreme Court can allow special leave petition, means that they can allow any matter before any court or tribunal. Not really. The word any here actually has to or should give you a hint. That is not clarified. There is a tribunal, that is the Armed Forces Tribunal. The Armed Forces Tribunal. Their cases cannot just be taken up by the Supreme Court whenever they want. So Armed Forces Tribunal, or the military tribunal as you call them, these are not the only ones that will actually come here. So out of the three given statements, the only one that is correct here is second. The correct answer here has to be two only. First and the third are wrong. The first statement wrong because not all the tribunals, military tribunals, do not give this power to the Supreme Court, and the Supreme Court and the High Court, both of them have the power of judicial review when it comes to deciding the cases or the laws passed by the parliament. Next, question number 36. Consider the following statements with respect to ad hoc judges of the Supreme Court of India. First, they are appointed by President with the prior consent of the Chief Justice of India. See, this statement itself is so wrong. How or why will the president take consent of someone? A president is at a higher position. How will or why will president take consent of someone? It is actually the opposite. They are appointed by the Chief Justice of India after prior consent of the President of India. Because see, you take consent, you take permission from someone who is higher to you. You don't take permission from someone who is lower to you, obviously. So that is why the Chief Justice of India appoints on the prior consent that has been taken from the President of India. Second, a distinguished jurist can be appointed as an ad hoc judge of Supreme Court. No. A distinguished jurist can be appointed as a permanent judge of the Supreme Court. That is true. But when it comes to appointing ad hoc judges means those judges which are appointed for a short period of time, when there are a lot of cases pending, when there are a lot of judges who are on holiday, etc. For some time period, you appoint ad hoc judges. Ad hoc judges are those who are eligible to become Supreme Court judges. So they are not really the same as the permanent judges. Ad hoc judges can become permanent judges. Jurists can become permanent judges, but not ad hoc judges. Both the answers or both the statements here given are actually wrong. Thus, the answer here has to be D. Again, not a difficult question to answer this one. Next, question number 39. With reference to E-Court's mission mode project, recently seen in the news, consider the following statements. Number 1. Its objective is to develop and implement decision support systems in district and subordinate courts. Number 1. Second, the Department of Justice under the Ministry of Law and Justice is the implementing agency for this. The answer here is actually first is correct, the second statement is wrong. Why? It is actually the High Court that is the implementing agency. The high courts are the ones which are chosen as the implementing agency for the E-Courts Mission Mode project. They will ensure that the decision-making support, they will ensure that the district courts, the subordinate courts will get a lot of help from the previous cases that have been adjudicated. They can learn from those judgments and they can increase their knowledge. It is the High Court that will be implementing it and not any Department of Justice. The correct answer thus is A. First statement is correct. The second statement here is wrong. Next, question number 41. This is about the GST. First, or the question is, which one of the following options is correct regarding the GST? Number 1. Every decision of the council is taken by majority of not less than 2/3. Wrong. By a majority of 3/4. Any decision that has to be taken or that has to be implemented, that will be or that will only go on if 3/4 of the votes are yes. Second, weightage of the vote in the central government or for the central government is more than the total weightage of all the states. Wrong. So basically, central government has a 1/3 weightage. All the state governments combined have a 2/3 weightage. So central government alone has 1/3 weightage and all others have 2/3 weightage. Second is also wrong. Third, council has to mandatorily meet at least once in every quarter financial year. This is actually correct. Yes, they have to meet at least once every financial year. All decisions are taken by consensus till now. No. Some decisions in the beginning were taken by consensus, but recently some state governments have not been very happy with what the central government is asking. So now the decisions, a lot of them are taken by voting also. Whenever 3/4 votes are in yes, the decision will be taken. So it's not that only consensus-based decisions are taken now. The decisions are taken on the basis of voting as well. Next, question 43. Which of the following are the functions of Election Commission of India? First, settling dispute arising out of allotment of election symbols to the political parties. Second, deciding on disqualification of members of parliament for anti-defection. No. For defection, the presiding officer decides. All of you would know that. Lok Sabha Speaker or Rajya Sabha Chairperson, they are the ones who decide. Enforcing the model code of conduct for election campaigns and penalizing a candidate who does not implement it right. First and third are correct. Fourth, appointing delimitation commission. No. Delimitation Commission is appointed by the President of India. It is the President of India that appoints the Delimitation Commission. Sorry. They are the ones who appoint this because they will redraw the boundaries, the constituencies, depending upon the changing population patterns. So fourth is also wrong. Ordering a repoll in event of violence influence the outcome of election, that is also true. 1, 3 and 5 are the powers of the Election Commission of India. Each and everything regarding elections in India is to be decided by the Election Commission of India, be it the schedule of the voting, be it where the voting will happen. They will decide if certain elections have to be cancelled, if there was some violence. They can decide all those matters. Question 47. Which of the following statements are correct with reference to Attorney General of India? Number 1. He or she can take part in proceedings of the joint sitting of the parliament. Yes, they can. They can accept appointment as a director in any company with the permission of the government. Yes. So this is a slightly tricky statement. They can accept appointment with the permission. If the statement would have been, they can accept appointment without the permission, that would have been wrong. They can first take government permission and then they can take up appointment as director in a government company. Third, they enjoy all the rights and privileges given to members of parliament. Yes. They can represent government of India with reference made to Supreme Court under Article 143. That is also correct. We just discussed what is Article 143. Article 143 is that article under which President of India can ask certain questions to Supreme Courts regarding interpretation of certain law, facts, etc. No, Chinna, he cannot vote. So the Attorney General in the Parliament can do everything except vote. They can be a member of a committee also. They can be in the joint sitting as well. They can even speak in the Parliament. They can do everything except vote. They will not be allowed to vote. So they don't have the voting rights as such. Next, again about Election Commission. This is about the State Election Commission. Which one of the following options is incorrect about the State Election Commission? Establishment of State Election Commission was first recommended by the Gadgil Committee on the Policy and Programs. Second, the Commission is entrusted with powers to conduct elections to panchayats and municipalities. Third, State Election Commission is an ex officio member of the Delimitation Commission. And fourth, administrative control over State Election Commission is vested with the Election Commission of India. Which of these is incorrect? The only statement that is wrong here is the fourth one. The Election Commission of India has no connection or has no control over Election Commission of a respective state. The state election commissions, they work separately. Their key responsibility is to conduct elections for panchayats and municipalities in the state. They are not working under the Election Commission of India. Election Commission of India does not control their working. All the other three are absolutely true. As you know, the state election commissions were set up after 73rd Constitution Amendment Act, when panchayats were given a constitutional status, because to conduct election for panchayats and municipalities, you required a new body at the state level, and that is how such a body was created. Question 50. Consider the following statements regarding constitution benches of the Supreme Court. First, they are set up by the President of India. No. President of India doesn't set up any benches. The Chief Justice of India will be the one who will set up constitution benches. The Chief Justice of India will be the one who will decide if there is a constitution bench required to hear any certain matter. If he thinks that yes, there is a requirement, the bench will be appointed. Verdict of a constitution bench can be overruled by a larger constitution bench only. That is actually correct. This is an example of how the word only can also be correct. As I was telling you earlier as well, please don't think whenever you have the word only, that will always be wrong. In this case, this is true. Third, there can only be one constitution bench at a time. No. See, Supreme Court always has multiple benches. The Supreme Court, for example, has so many judges, 33 judges plus one Chief Justice of India. They have multiple benches. If you go to Supreme Court, there are multiple courthouses. So in every room, there is a case being heard at the same time. So there can be more than one constitution benches also. That is not a condition. You have to choose which of these was incorrect. First and third are incorrect. So the answer here has to be B. The answer here has to be B. First and third are incorrect. And we are now halfway past our discussion. Let me quickly again take up a few questions that were assigned to me before we move ahead. Let me see. Just a second. Just give me a moment, guys. I'm trying to navigate. Just a second. Okay. One question that I have here is does the advocate need to be registered to any bar council or the bar council of Supreme Court? The advocate can be registered in any bar council across the entire country. Then I have a question, difference between appellate and constitutional jurisdiction. Very different. There is nothing called constitutional jurisdiction of the Supreme Court. Appellate jurisdiction means those cases that can come to Supreme Court by way of appeal. There is nothing called constitutional jurisdiction, so I'm not sure where you heard that word. Then I have a question. Generally, the bills will be lapsed when the Lok Sabha is dissolved. Resolution is not within the meaning of the bill. No, this resolution for the Supreme Court judge removal is separate. It is specifically mentioned in the law that these ones will not be dissolved or will not be lapsed even when the Lok Sabha is dissolved. Then I have a question. If one High Court declared central law is unconstitutional, then this decision applies to all over India or Supreme Court can decide on this matter. So till the time the Supreme Court decides this matter, Supreme Court takes up the matter again, till that time the law will be applicable across the country. But if the Supreme Court then again takes up the matter, they can again change this. I'll give you a real example. So a few months back, Punjab and Haryana High Court was hearing a matter. The matter was about a Muslim girl being married at the age of 15. Now, the case here is that as per the law in India, the minimum age for girl marriage right now is 18 only. But as per the Muslim law, the girl can get married after she attains the age of puberty, after 15. So, which law will be considered as the final law? Would a Muslim girl be allowed to marry at the age of 16, 17, etc.? So, Punjab Haryana High Court was hearing the matter. Recently, they allowed this marriage to go ahead. Supreme Court then said that in that case, it is fine, but let this not be a law for across the entire country. Let us hear the matter and decide. So, if the Supreme Court doesn't say anything, then the law is applicable across the country. If the Supreme Court comes in and says, no, we will now decide, then they can change that. Then Syed is asking, but the Chief Justice of India says, I will uphold the Constitution and the laws here uphold are meant to defend only. See, Syed, the problem here is you cannot just change words and think this means the same, so my answer is right. That is not how it works. The reason why we have a Constitution of India is that the Constitution has certain specific words written. So if I ask you who speaks these words in his or her oath, then the answer has to be the president, because that is what the oath is. You can't say their oath means the same thing, because that is not what the question was. The question was not whose oath means the same thing as this. It is just like thinking of excuses how to make my answer right when my answer is wrong. When the answer is wrong, accept it. You are not asked about the meaning of the oath. You are asked about the certain exact words written in the oath. These words are written for the president only, as simple as that. So I don't think you should be concerned about that. Okay. So these were the questions that I had so far. Let's see, moving on, what are the other things that we have. Next is question number 52. Just give me a moment. Just a moment. Okay. Can you please confirm if you can hear me and you can see me properly again? You can hear me, you can see me properly? Perfect. Thank you so much. Thank you. Okay. Tushar has a comment. Tushar is saying, Attorney General enjoys all the rights and privileges. They don't enjoy the right to vote. So how can that be right? So usually when you say rights and privileges, they are not talking about those kind of rights. So for example, when you say rights and privileges. They are talking about right to freedom of speech and expression. Those are the kind of rights that they're talking about, not the right to vote. Perfect. Let's move on then. Next was question number 52 that we'll take up. Consider, or with reference to a Central Vigilance Commission, that is a CVC, consider the following statements. Number one, it is an independent body responsible to the Parliament of India. Second, they exercise superintendence over the CBI in certain cases. Third, CVC can order investigation related to the corruption of judges of the Supreme Court and the High Court. Which of these is incorrect? You have to tell which of these is incorrect, not the correct one. First, it's an independent body responsible to Parliament. That is actually correct. In simple terms, there is no ministry or department that they are responsible towards. So they don't answer to any ministry, they don't answer to any department. They can only answer if the questions are asked to them about from the Parliament of India. Second, the CVC has superintendence over CBI. That is correct. If you remember, if you have read about the CBI, there's a famous case called the Vineet Narayan case. The Vineet Narayan case of 1997. In this case, the Supreme Court said that the CVC should look into the working of the CBI, especially when it comes to Prevention of Corruption Act cases. So any cases that CBI is working on, which are under Prevention of Corruption Act, those cases, they should be looked over by the CVC. Third, they can order investigation to corruption of High Court, Supreme Court judges. No. High Court, Supreme Court judges are not within the jurisdiction of the CVC. Since you had to choose which of these is incorrect, the answer has to be C, because out of the three, only the third statement is incorrect here. The first and the second statement here are correct. Next, which amongst the following best describes the principle of parens patriae jurisdiction recently seen in the news? So as you know, there are a lot of different types of doctrines or jurisdictions that the court keeps on giving. The correct answer here is C. It is a doctrine where the court acts as provider of protection to those who are unable to take care of themselves. Now, what exactly is this issue? So you would have noticed a few years back, there were instances where the court said that, for example, Ganga river will be called a living entity, or the tree will be called a living entity, the rivers, the mountains will be called living entities, so on and so forth. So basically what happens in these cases is, because let's say that you are going and polluting the Ganga river, you are just throwing your waste, obviously the river cannot say anything back to you. The river is not really living, but the court comes in there to protect the river by giving it the right that a living person would have. So you cannot do the same that you are doing to a living person that you are doing to the Ganga river. So when the court says we are giving the status of a living entity to a natural thing, that is called the principle of parens patriae. That means the court will give protection to those who cannot take care of themselves. That includes giving this kind of a living being status to those things who are not even living. Next, question number 60. Which of the following statements is or are not correct regarding linguistic minorities mentioned in the Constitution? They have the right to set up and administer education institutions of their choice. Absolutely correct. You have read this in the fundamental rights. To be identified as linguistic minority, the language needs to be mentioned in the 8th schedule of the Constitution. No, there is no connection like that. Absolutely no connection. Nowhere does it say that linguistic minorities will be those whose language is mentioned in this 8th schedule. That is not true. Special officers for linguistic minorities can investigate all matters regarding safeguards provided to them. This is also correct. We have a special officer for linguistic minorities. This is in fact a constitutional body that was set up by the government of India when the new states were being carved out early on in 1950s. Thus, the first statement and the third are true, second is wrong. You have to tell which of these is not correct. So the answer here has to be B. 2 only is not correct. The other statements here are correct. Next, question 62. With reference to India, which of the following are the objectives of judicial review? To uphold the supremacy of the Constitution? Yes. To prevent the misuse of power by legislature? Absolutely yes. To maintain equilibrium between center and state? That is also true. How? A lot of times what happens is the center government starts making the laws that are in the state list. So the state governments get very anxious. They think that they already don't have power, and the central government is now making laws on stateless matters also. So state governments then go to the Supreme Court. So yes, to maintain equilibrium between center and the states also, the Supreme Court can hear such matters. So judicial review helps there as well, and to protect fundamental rights, obviously. The correct answer here is D. All these are objectives given to the Supreme Court for using the judicial review. I have a question here. If Telangana High Court declared the IT Act as unconstitutional, the effect will only apply to Telangana or whole of India? Whole of India. As I told you, High Court orders are not to be restricted in the state itself. Doesn't matter if the High Court has given an order, that will be applicable to around the entire country. Then, question 65. With reference to political parties in India, consider the following. Number one, only a citizen of India can become member of a political party registered with the Election Commission of India. Second, as per RPA 1951, a political party can be set up only for the purpose of contesting elections to parliament and the state legislature. Third, only a national or state party has the authority to accept any amount of voluntary donations from the public. Third statement is a very easy statement to eliminate. See, there are very few national and state parties. So you cannot say that only national and state parties will be able to get the voluntary donations. Any political party in India is allowed to take as much voluntary donations that they are getting. They even get tax exemption on that. So the money that is being donated to political parties, the political parties don't have to pay an income tax on that. They are exempted from that. They just have to give a record of how much money they are getting to the Election Commission of India, and they will get the exemption. It's not only some political parties that get the money. So that is why the correct answer would be A. 1 and 2 are correct. The third statement here is wrong. The third statement here is not correct. Next, with reference to National Investigation Agency NIA, consider the following statements. Number one, NIA can declare organizations as well as individuals as terrorists. Second, NIA can designate Sessions Court as a special court for trial of scheduled offenses under the NIA Act. Third, the NIA has the power to investigate offenses committed outside India as well. First and third are correct. Second is wrong. See, NIA does not set up any special courts. The power to set up the special courts is with the central government of India. It is the central government only that can say that we are the ones that will be going ahead and making sure that a specific sessions court, a district court is converted into a special court. The NIA cannot do that. The NIA does not have the power to convert courts for something else, for some other purpose specifically. So the correct answer has to be A. 1 and 3 are correct. The second statement here is wrong. Next, consider the following statements regarding the Central Administrative Tribunal, that is the CAT. It has jurisdiction authority to punish for contempt of itself. Second, the appeal from state tribunal lies with the Central Administrative Tribunal. Third, it is not bound by the Code of Civil Procedure 1908. This we already discussed just recently. The chairman and every other member of tribunal is appointed by the president after consultation with the Chief Justice of India. Which of these given statements is or are correct? See, when it comes to administrative tribunals, you all have read about administrative tribunals, Article 323A, Article 323B. Remember, Article 323A that talks about administrative tribunals. There is no hierarchy in administrative tribunals. There is no hierarchy here. Meaning that it doesn't work like this, that you first go to state tribunals, then if the matter is not in your favor, then you go to central tribunals. No, that is not how it works. There is no hierarchy as such. In the other tribunals, Like if you have an income tax tribunal, if you have a tribunal about company law, if you have a tribunal about some other matters, environment, etc. In those matters, you have a hierarchy of tribunals. Hierarchy means if your matter is first heard, the decision doesn't come in your favor, then you can appeal in the appellate tribunal. That is fine. But in the administrative tribunals, that doesn't happen. So in administrative tribunals, there is no concept of hierarchy, there is no concept of appeal. First, third, and fourth are correct. Second statement here is wrong, because in administrative tribunals there cannot be a hierarchy. For other types of tribunals, there can be a hierarchy. That is a big difference between the two types of tribunals that we have. Next, with reference to PIL, public interest litigation, usually seen in the news, consider the following statements. Number one, principle of locus standi is relaxed while filing a PIL. Absolutely correct. What is locus standi? Locus standi simply means that usually what happens, let's say you go to the court and you say, I want to file a case. Usually you will only be allowed to file a case if you are related to the case. I'll give an example. Let's say you're walking on the road, you see one person hitting the other person. You don't know either of the two. You don't know who was hitting the person. You don't know who was getting beaten up. You go to the court and say, I want to file a case. Usually this case will not be filed. Why? Because you are not a locus standi, meaning that you are not related to that case. Who is hitting who? You are just there making a reel, making an Instagram reel because you want likes for that, but you're not related to the case. So usually your case will not be accepted because you don't have a locus standi. In PIL, that is not true. Why? The entire concept of PIL is you are filing a case in the interest of the public, not for yourself, not for someone you know personally, but in the interest of the public. So for PIL, these kind of cases are, for example, if there are people in the prison right now and police is not treating them properly, police is not giving them proper food, police is not giving them anything to relax or eat or whatever, they can't go to the court to fight a case for themselves. No one else will file a case for them. So you can go to the court and file a case that I am filing a case on behalf of them in the interest of the public. That may be allowed. So in case of PIL, locus standi is relaxed. That is true. Second, the High Court can suo motu initiate a PIL, meaning that the High Court can say we are ourselves starting a PIL. That is also true. Suo motu means by itself. Third, the PIL can be filed only against central, state, or local governments and not against individual. That is also true. See, again, the entire, you can just see the full form and understand. Public interest litigation. You are filing a litigation, you are filing a case in the interest of the public, not for your individual interest, not for interest of someone you know, for the interest of entire public. And that is why it is not allowed to be filed against an individual. It can be filed against the state, against the government, etc. The correct answer thus is D. All these three are correct statements about the concept of PIL. Next, which among the following factors enable the independence and unbiased nature of audit by the CAG? Number one, removal of CAG requires a special procedure similar to that of Supreme Court judge. Absolutely correct. Just like a Supreme Court judge is removed, in the exact same manner, CAG can be removed. It's not an easy process. Salary, condition of service cannot be varied to their disadvantage after the appointment. Yes, again, absolutely correct. Third, disallowing his or her holding any other government office after his or her term expires. Absolutely correct. All these are provisions made specifically to ensure that the CAG works independently. Because what happens is, let's say if you are the CAG and you have an option that after I retire, government might give me one more job so I'll earn more money. If you have that option, then you will always try to favor the government. So that is not allowed, that option doesn't exist, you don't favor the government. That is why it is disallowed from holding any office after your retirement. So all these are true. The correct answer here has to be B. Next, something that is very recently in the news, just a few weeks back. Remote voting machine recently seen in the news is related to which of the following? Number one, allowing remote voting for NRIs? No. Enabling remote voting for all citizens of India? Not really. Remote voting for the domestic migrant workers? Yes. See, if you have been reading the newspapers, Hindu newspaper, etc., you would have seen there are many articles that are written these days about the fact that India's voting percentage is not increasing. If you look at the past few years, in fact, past few decades, India's voting percentage usually remains around 65%. In some places, individually, it might go up to 70, but on an overall average, it goes to usually 65% only, meaning that in such a huge population, just imagine one out of every three people are not voting. So when you have such a huge population, one out of every three are not voting, that means that a lot of people are not exercising their right, and that can impact the election results as well. So Election Commission of India is thinking of ways to increase the voting in India. Now there are many ways that people have suggested. Many ways, for example, you should allow online voting, NRIs, etc. But the problem is, rather than focusing on NRIs, NRI is a huge, is a population which is not very big as compared to those in India who have gone from one state to the other, and that is why they cannot vote. Migrant voters, domestic migrants are huge. And domestic migrants are not just laborers. Just imagine that after class 12, you join college. A lot of you might go to college in some other city, might have already gone to in some other city. I went to college in some other city. When you are in first year of your college, or in some cases even before you enter college, you will turn 18, so you become an eligible voter. Now just imagine how many of you, when you were in college, went back to your home city just to vote. Did you go back just to vote? Did you take an off that I will go and I will go ahead and vote because I really care? Even if you care, you might not be willing to spend money, go all the way back, take a off just to vote. So the Election Commission of India has thought that because such a huge population of India, population of those who are migrating in search of jobs or study, etc., within the country to some other city where they cannot vote, for them, they have a new machine called remote voting machine, similar to EVM only. So that, for example, I am living in Bangalore and my voter ID, let's assume is of Delhi. So in that case, what happens? I will not have to go to Delhi. When the elections are happening in Bangalore only, I will be allowed to vote. This is the idea. The problem here is, what happened here was, Election Commission of India was trying to hold a demo for the political parties. Election Commission wanted to show them the machine, how does it work, so that the political parties don't complain later on that the machines are bad, it is corrupt. But the political parties boycotted it. They did not really listen to that. So Election Commission is ready to go ahead with this idea, but how will it be implemented? That is still a problem. I'll give you an example. Let's take a very simple example. See, if there are all India elections that are happening, like the Lok Sabha elections, then it is fine. Why? Because let's say the Lok Sabha elections are happening, then if I am living in Bangalore, my voter ID card is of Delhi, I can go to Bangalore voting booth, because voting will be happening everywhere in India. So I can go to Bangalore voting booth, vote in this machine so that my vote is counted in Delhi. But the problem will be for state elections. Let's assume only Delhi elections are going on. Now, if Delhi people are living in all cities across the country, do you think for Delhi elections, the Election Commission of India will set a voting booth in every city, that wherever Delhi people are, you can go and vote? That is not possible. So for state elections, it might not really be a feasible idea if you are understanding it. If population is spread so much across the entire country, the Election Commission obviously will not, specially for one state election, set up voting booth everywhere. For Lok Sabha elections, when the elections are happening everywhere in the country, that is fine. So this idea has to be seen if they are successful in this or not. But again, at least they are trying their bit. Let's see. Next, question 74. Who among the following appoints the persons other than district judges to the judicial service of a state? Number one, Chief Justice of India with the consultation with the State Public Service Commission. Second, Governor after consultation with the State Public Service Commission and the High Court. This is correct. Just remember this. When it comes to appointment of district judges, they are appointed by governor after consultation with the state high court. So governor will consult with the state high court, which is the judge that we should appoint. When it comes to judges other than the district judges, that is in the lower courts, these judges are appointed by governor after consultation with high court and the state public service commission. Many of your friends, if you notice, might tell you they are preparing for the judicial exam. There is an exam called PCSJ. Have you heard of this? PCSJ exam. Many people prepare for this also. We are preparing for judicial exam. So what is it that they are preparing for? This is what they are preparing for. That when you pass this examination, then you might be recommended here. So this is what that exam is all about. So judges other than the district judges are appointed by governor only after consultation with the state high court and the state public service commission. 76. Consider the following statements. Number 1. Article 76 provides for the post of Solicitor General of India to assist the Attorney General. Second, governor appoints a person qualified to be a judge of the High Court as the Advocate General of the state. Second statement is true. First statement is wrong. See, understand this. We have a post of the Attorney General. Attorney General, as you know, is a constitutional body under Article 76. In simple terms, the Attorney General is the main legal advisor to the Government of India. Because the Government of India has a lot of legal cases, there are a lot of cases where the Government of India might have to be represented by a lawyer. So apart from Attorney General also, the Government of India many times appoints certain other lawyers also. So usually to help them, we have another position called Solicitor General. Even below them, we might have additional Solicitor Generals. Usually, government can appoint up to 4 additional Solicitor Generals. Now remember, these positions, Solicitor General and additional Solicitor Generals, are not constitutional positions. They are not constitutional positions, meaning that the Constitution of India doesn't say that these positions have to be established. The Constitution of India only talks about Attorney General, that Attorney General is a constitutional position that has to be established. The other positions of Solicitor General, additional Solicitor General are not constitutional, so they don't have to be established necessarily. That is why, if you look at the statement, the first statement is wrong, because Solicitor General is not someone who has to be appointed compulsorily. Because these are not constitutional positions, the government usually has the freedom to appoint whoever they want. Usually, Solicitor Generals or additional Solicitor Generals are those who are qualified to be Supreme Court judges. So they are usually Supreme Court lawyers only. Because when you look at the Government of India, most of their cases are in the Supreme Court only. So they look for those lawyers who have experience in the Supreme Court. But again, the government from time to time decides what are the criteria that they have to follow in order to appoint such positions. Next, 79. Fast and secure transmission of electronic records recently seen in the news is what? Platform for sharing criminal records between the different states, platform for instantly sending e-copies of court orders. This is absolutely correct. We just discussed about this. This is actually a platform that will send court orders, any court orders that have to be given. These are sent instantly online. This is called FASTER system, FASTAR. It stands for fast and secure transmission of electronic record. This was in the news recently as well. Next, question 80. Which one amongst the following is not correct about Election Commission of India? First, President by notification can increase or decrease the number of election commissioners. Absolutely true. As you know, it started as a 1-member body, then it became a 3-member body, then again a 1-member body, and now it is a 3-member body for many years now. Difference of opinion amongst the Chief Election Commissioner and others are decided by majority. Absolutely true. So although we have Chief Election Commissioner and two other election commissioners, that does not mean that the Chief Election Commissioner has more powers. Whatever matters have to be decided, they are decided by a majority. Matters, for example, let's say that an election has been conducted. Let's say in certain city there was a lot of violence in the elections, and there are news stories that are being reported that maybe the election was not fair in a certain district. Now, in that district, do you cancel the elections? Do you hold the elections again? Do you disqualify the candidate? What action is to be taken? That decision, when the Election Commission of India has to take, they take it via majority. It's not that the Chief Election Commissioner will tell what happens. It's decided by the majority only. Third, election commissioners hold the office for a term of 6 years or until they attain the age of 65. True. And fourth, the mode of removal of election commissioner is the same as that of judge of Supreme Court. This is wrong. This is where many people actually get this answer wrong. Understand something. There's a very key difference between Chief Election Commissioner and the election commissioners. The Constitution of India says that there shall be a Chief Election Commissioner and as many election commissioners as the president decides from time to time. Please understand this. The Constitution of India says there shall be a Chief Election Commissioner and as many election commissioners as the president decides from time to time. Now, what is the interpretation of this? The interpretation is because the Constitution of India says that it is compulsory to have the Chief Election Commissioner, others the president will decide. So what has happened is all the conditions about the powers, the functioning, the removal, appointment, everything in the Constitution is only about the Chief Election Commissioner and not about other election commissioners. Meaning that the Constitution says Chief Election Commissioner will be removed in the same manner as a Supreme Court judge. That is absolutely correct. But what about the other election commissioners? The other election commissioners are not removed in that manner. The other election commissioners can be removed by the president on the advice of the Chief Election Commissioner. That is a big difference. If the statement would have said that Chief Election Commissioner is removed in the same manner as the Supreme Court judge, that would have been correct. But if the statement is about the other election commissioners, they are not removed in that manner. The other election commissioners can be removed by the President of India on the advice, on the recommendation of the Chief Election Commissioner. That is why the answer here is D. The fourth statement here is wrong. The other statements here are correct. Next, which one of the following is correct about electoral bond scheme? Number one, they can only be purchased by Indian citizens at designated SBI branches. Absolutely correct. There is no limit on, can only be purchased by Indian citizens at designated SBI branches. Is it correct or not? I'm sorry, I did not read it properly. Is it correct or not? Only be purchased by Indian citizens at designated State Bank of India branches. Why is it wrong, by the way? Why is it wrong? Those who are saying this is wrong. Yes. So basically, they can be purchased by Indian companies as well. By companies as well and not just citizens. So companies, in fact, if you look at the record of the donations that the political parties get, majority of them are by companies and not citizens. So that is why first is wrong. Second, no limit on the number of electoral bonds a person can purchase. Yes, this is correct. No limit on the number of bonds or number of bonds that anyone can purchase. Third, political party is required to encash the bond within 30 days. It is right or wrong? Is it right or wrong? Can or does a political party get 30 days to encash the bond? What do you think? This is wrong. Which is what is the correct one? Version? Yes, 15 days. Right. They get 15 days and not 30 days. Tell me this also. If after 15 days, let's say a political party deposits a bond of 100 crore rupees, okay? Will the political party say, we have come after 15 days, give us interest also? Will the interest be given or not? Because we have come after 15 days, you kept the money for 15 days, give us the interest also. Will that be given? No. Yes. No interest will be given. No interest is offered. Cash, digital payments, or a check can be used for buying electoral bonds, right or wrong? What do you think? It is wrong, obviously. Why is it wrong? Tell me that. Why is it wrong? Why is it wrong? Yes, cash is not allowed. Cash is not allowed. You cannot have it through cash because, again, the entire problem with the cash will be it will be anonymous. So only the second statement here is correct. All the other statements here are wrong. Next, 83. With reference to Joint State Public Service Commission in India, consider the following. As you know, if two or more states request, the parliament can go ahead and make a joint public service commission also that will work together for multiple states. Unlike the public service commission at the center and the state level, JPSC is a statutory body, right? As we just discussed, parliament will create this body if the two or more states request. Constitution has not created it, so it's a statutory body. Second, chairman and members are appointed by the governor after concerned state through consensus. No, they're appointed by the President of India. For UPSC, president appoints. For state PSC, the respective governors will appoint. But when two or more states together have a joint public service commission, in that case also the president will be the one who will decide and not the governors. Third, they present annual reports to governors to the each state concerned. What do you think, right or wrong? Would they present the annual report to the states concerned or would they present the annual report to someone else? What do you think? Those who are saying wrong, by the way, why is this wrong? Those who are saying wrong, why is this wrong? Present to governor, present to president, many people are saying. Okay, this is also correct. This is also correct. They don't present annual report to the president. See, what will the president do with the report? This is a report about the state government that they are actually serving. So they will give respective report to the state governors. The state governors will then give the report to the legislative assembly to discuss. First and the third statements are correct. The answer here has to be A. The answer here has to be A. As I told you, appointments are done by president. This is in fact written. This is in fact written in the law as well. It is not the governors that appoint them. Secondly, as I told you, their annual reports will not go to the president. They will go to respective governors only because they mainly talk about how exactly is it that the recruitment process went on. Now, there is some confusion here that I see in the chat also. Some people are saying, is it a constitutional body? No, it is not a constitutional body. See, yes, there is Article 316. Let's understand something. What does Article 316 say? Does Article 316 establish Joint Public Service Commission? No. What is Article 316? Article 316 says Parliament may establish Joint Public Service Commission. So they are not establishing it. Parliament will establish it if there is a requirement. So it's a statutory body. Just because it is written in an article doesn't mean it becomes a constitutional body. It is exactly the same as tribunal. Do you think tribunal is a constitutional body? I can say Article 323A says that there can be administrative tribunals. So do you think administrative tribunals are constitutional bodies? No, they are not. Why? Because the article says Parliament may establish it. Constitution not establishing the body. Those bodies which are established by the Constitution itself, those are constitutional bodies. When the Constitution says that the Parliament may establish such a body, that will be a statutory body. So make sure you understand the difference between the two. Just because they have an article associated with them doesn't mean that they will become a constitutional body all of a sudden. It depends on how are they established. Next, question number 84. With reference to Indian judiciary, consider the following. Number one, all the courts in India can enforce both central and concerned state laws. Second, judgment of Supreme Court is binding on all courts in India. High courts have the power to punish for the contempt of subordinate courts under it. All these given statements about the judiciary are absolutely correct. All these are absolutely correct. That is how the Indian judicial system works. Let's move on to the next question then. We move on to question number 90. Which of the following are advantages of resolving a dispute through alternate dispute redressal mechanism? Basically, ADR, when you talk about alternate dispute resolution, that simply means apart from the courts, how can you resolve the disputes? For example, it can include lok adalats, it can include gram nyayalayas, it may even include tribunals. So basically, all these places where you can go and resolve a matter, which are not courts, those are called alternate dispute resolutions. They are cost effective. Yes, lok adalats, for example, you don't have to pay any money. Flexible in choosing the applicability of the laws. Yes, they don't have to follow the same civil procedure code. They can choose their own types of codes. They ensure confidentiality. Yes, it's not that the press or media is covering anything. Everything that is being discussed is only known to parties involved in the case. And promotion of cooperation between the parties, that is also true. All these are true. All these are advantages that we get with alternate dispute resolution, unlike the courts. That is why governments also want many people to opt for these kind of solutions only. I have Chennai is asking, state PCS chairman are appointed by governor. Yes, state PCS chairperson members are appointed by governor. UPSC at the central level and the joint commissions, they are appointed by the president. Next, 91. This is a difficult question, I would say, because in this kind of question, you either know the answer or you don't know the answer, you cannot really guess. Which amongst the following are provision under Representation of People Act of 1950? Now, as you know, RPA, Representation of People Act, there are actually two types of these acts. There is RPA 1950 and there's RPA 1951 actually. They are two different laws. The first two that you see here, allocation of seats, how many seats will be given to which state in Lok Sabha, in legislative assemblies, and preparation and revision of electoral rolls, these two are written in RPA 1951. Sorry, 1950. On the other hand, the last two, dispute resolution about elections and grounds for disqualification of members of parliament, these are parts of RPA 1951. Now, it really depends. If you have read this, then it's pretty easy question for you. If you have not read this, then it becomes difficult. So I'm not saying it's difficult for everyone, easy for everyone. Depends on if you have read it or not. But usually, especially for the prelims examination, people leave RPA 1951 because if you look at the syllabus, RPA 1951 is a part of the main syllabus in GS2. So a lot of times people usually leave this and they think I'll read it for the mains exam. So for the prelims exam, it becomes slightly confusing. But the answer here has to be A. The first two are part of RPA 1950. The next two are part of 1951 RPA. Next, 92. Which one of the following options with reference to Article 142 is incorrect? Now, Article 142 is one of the most important constitutions in the one of the most important articles in the Constitution of India. There have been multiple questions asked on this by UPSC in the past as well. In simple terms, Article 142 gives almost unlimited powers to the Supreme Court to give any kind of judgment, any kind of directive. Article 142 says the Supreme Court of India can issue any judgment, any directive that will ensure complete justice in the society. In the name of ensuring complete justice in the society, the Supreme Court can give any order. That can include very strange orders as well, asking everyone to compulsorily have national anthem before the movie, or they can have other types of orders as well. But Article 142 gives this power to ensure complete justice in the society. This power is given to the Supreme Court. Let's see the statements. First, It seeks to provide complete justice to litigants who have suffered due to intricacies in the legal justice system. Yes. Powers given are exercised by high courts. No, only by Supreme Court. High courts don't have this power. It is only the Supreme Court of India that has been given the power to use Article 142. Under this article, order passed can be reviewed by constitutional bench of the court. Yes, obviously it can. Supreme Court of India is not constrained by laws made by Parliament while exercising this power. Absolutely true. As I told you, they don't have to see what laws are being made by the Parliament, whatever is happening. They can give whatever order they want, which in their view will bring complete justice in the society. And that is why this gives almost unparalleled powers to the Supreme Court. Next, consider the following statements about Niti Aayog. Prime Minister is the ex officio chairperson of the Niti Aayog. Yes, Prime Minister heads the Niti Aayog, just like the Prime Minister used to head the Planning Commission also. Vice Chairman of Niti Aayog is appointed by the Prime Minister and holds the rank of a Cabinet Minister. Yes. Lieutenant Governors of UTs are members of Governing Council of Niti Aayog. Yes. All these are true. Pretty easy question to answer this was. As you know, Niti Aayog replaced the Planning Commission. Both of these are executive body. Planning Commission also used to be an executive body established by the Nehru government. It was removed by a simple order given by the Modi government, and they replaced it with something called the Niti Aayog. There are a lot of differences between Niti Aayog and Planning Commission. First major difference being in the Planning Commission, there was no representation from the states. In Niti Aayog, there is a representation from the states. Secondly, Planning Commission had a lot of money-related powers. They advise the central government how much money should be given to the states for their respective 5-year plans. In case of Niti Aayog, they don't have such money devolution powers as such. So it's a very different body as compared to what we used to have earlier. Next, question 96. Which one of the following statements defines the word net proceeds of tax certified by the CAG as per Article 279? You see this phrase time and time again, that the CAG gives the net proceeds of tax certificate, or they give the net proceeds certificate for the government of India. Now, what does it mean? It means the proceeds of tax minus the cost of collection. Proceeds of tax means the tax collection in simple terms. In simple terms, what exactly is it that, or how much money is it that the government of India is collecting in the form of taxes minus the money they have spent while collecting it? So they, for example, they would have given money to people, to the government agent who would have collected the taxes, government's expenses. If the government made a website where you can go and submit your taxes, etc. So whatever the government's cost is of collecting the tax, you remove that from the amount of tax collected. That becomes a net proceed of the tax. Next, ED, something that is in the news. With reference to Enforcement Directorate recently in the news, consider the following statements. Number one, ED is a nodal agency for conducting financial investigation into cases involving money laundering and bank fraud. Second, it comes under control of Department of Revenue under Finance Ministry of the Government of India. Both of these given statements are absolutely true about ED. If you have seen, ED has recently been a lot in the news. ED is a body mainly handling money laundering cases in India. So we have a law called PMLA. PMLA is Prevention of Money Laundering Act. So when you acquired money through illegal means and you are misusing that, you are trying to buy legal things and make it legal, that is called money laundering. Money Laundering Act basically provides for ED as well. If there are money laundering cases, ED will come into the picture. For example, if someone has just stolen the money from the bank, that is not a case where ED will come in. ED will come in when that stolen money is being misused to buy property, when it is being misused to buy something, to turn it into from black money to white money. So ED mainly comes into picture of money laundering. Laundry, as the name suggests, when you clean something, you launder your clothes, you do laundry. So when you clean black money, turn it into white money, that is money laundering. This is where ED comes into the picture. Second last question. Which of the following are the functions of National Commission for Scheduled Tribes against a constitutional body? Investigating, monitoring all matters related to constitutional other legal safeguards of scheduled tribes. Yes, correct. Second, taking measures to confer ownership rights of minor forest produce to scheduled tribes. Yes. Providing financial assistance to members of scheduled tribe. No. See, there are different schemes of the government of India under which the government might give certain financial help to members of the scheduled tribes, but National Commission for Scheduled Tribe does not do this. The National Commission for Scheduled Tribe, for example, can act as a civil court also. They can look into complaints of people from the scheduled tribes. If there are certain scheduled tribes that have been discriminated against, if they are not getting the help of government policies, then these kind of helps are given by National Commission for Scheduled Tribes. But this Scheduled Tribe Commission does not give financial help as such to people of Scheduled Tribes community. They take measures to eliminate practice of shifting cultivation by tribals. That is also true. They do all these things. They help ensure that the living of the scheduled tribes becomes better in India, that they get all the help from the government schemes that the government has released, but they are not responsible for giving financial assistance as such. The government might run certain schemes for that, but the National Commission for Scheduled Tribes does not do that on its own. Next, question number 100. Which amongst the following criteria is correct regarding the recognition of a party as a national party by the Election Commission of India? As you would have read in Indian polity, there are national parties, there are state parties which are recognized by the Election Commission of India depending upon their performance in the election. Which of these is a criteria under which you can become a national party? First, if you become a state party in 6 or more states, no. The correct version is 4. If you become a state party in 4 or more than 4 states, you become a national party. An example is the National People's Party. It's a party from northeast part of India. It's a state party in 4 states, and thus it has become a national party. Second, political party must manage to get 6% votes in 4 or more states in Lok Sabha election or to a legislative assembly and win at least 4 Lok Sabha seats. That is also correct. Second statement is correct. Third, a political party must manage to get at least 10% of total seats in Lok Sabha general election. No, 10% seats is a lot of seats. Apart from BJP, no party right now has 10% seats in the Lok Sabha, so that is obviously wrong. This is 2%. So if you get at least 2% seats in the Lok Sabha election, that is correct, not 10%. And last, if a political party gets 8% votes, then you become a state party. So this is actually partially correct. If you get 8% votes in a state election, then you become a state party and not a national party. Since the question was how do you become a national party, the fourth statement will be wrong. The fourth statement, that condition is true to become a state party and not a national party. So the correct answer here has to be B. This is the one that is correct. This finally brings us to the end of the discussion. As I told you in the very beginning, the purpose of the discussion is not to see how many marks you get, how many marks you did not get. That you already know. The purpose of discussion is to see whether you were thinking in the right manner, in the right direction while solving a question or not. If that is true, if you have taken the correct approach, that is great. You don't have to worry about your score right now. Make sure if you come across a difficult question, a tough question, be happy because you are seeing all those questions before the prelims examination comes in. Having said that, all the very best for the upcoming test. I hope you do not miss any of the tests. We will meet each other in some of the later sessions. Thank you so much. Bye-bye. Have a good day. Jai Hind.